Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally. Steve, one of our viewers from one of the previous episodes emailed us a question about firearms law. So I understand that's what we're going to talk about today.
We're going to do our best. Firearms laws in California can tend to be a bit confusing, not only for the courts, but attorneys, and certainly at times even for law enforcement.
Well, every state has their own laws, and they're certainly not the same. You cross the border and everything changes. If you travel and you want to carry a firearm, you should do your homework and know beforehand, or you might be subject to arrest or loss of your rights.
Exactly. And in recent years, of course, California's been subject to a lot of new firearms laws, ammunition laws, related laws. And with every session of legislature, we seem to be getting new laws and new restrictions are proposed. And today what we're going to talk about are the general rules regarding firearms, and to a limited extent, your right to protect your home, property, yourself, and family members. But because it is such a complex area, I really would like to start at the basics, because a lot of people don't even understand what a firearm is.
Well, let's talk about that. What is a firearm in California? Does it include pistols? Does it include rifles, shotguns, or other things that people don't typically consider firearms?
Well, first thing, let's talk about what is a firearm.
Okay.
Now, a firearm is defined in California as any device designed to be used as a weapon from which is expelled through a barrel, a projectile by the force or of any explosion or other form of combustion. Just that in and of itself, you can think of a lot of things. Mortars, some fireworks, perhaps any type of destructive device.
I was thinking of a bottle rocket.
That too. Any rocket specifically, any rocket propelled by a projectile launcher, any similar device, if it contains an explosive or incendiary material, whether or not it's designed for emergency or distress signaling. A lot of people have boats that have flare guns. Those are firearms under the definition of firearms in California.
I have an interesting, can I ask a question here? Let's say you have like these rocket launchers the kids have, they light a fuse and but that's not carrying an explosive device, but it's burning something inside.
Under the definition in California, rocket-propelled projectile, okay, can fit under the general classification of firearms. Now, obviously, if somebody's carrying one in their vehicle, most officers are not going to view that as a firearm that's concealed, et cetera.
Right. It was just an interesting factual question, I thought.
Right.
But a firearm, it doesn't include an unloaded firearm that is not defined as an antique firearm. Is that correct?
That is defined as an antique.
That is defined.
Now, that's under federal law. It's got to be, if federal law says that a firearm is an antique firearm, those laws don't apply in California. A lot of different laws don't apply to antique firearms in California. But you really have to take a look at that, because there's specific dates that apply. And it does not include replicas of firearms. There was a modern day manufacturing of an antique firearm is a modern firearm.
And that's under federal law, what's an antique
Correct.
firearm. Okay.
But we also have BB guns. They expel a projectile, such as a BB or a pellet. And if they're not a firearm, if they expel a projectile smaller than 6 millimeters, and that's roughly .24 caliber. And that's using it, propelling it by use of air pressure, gas pressure, spring action, or a spot marker type of gun.
What is a spot marker gun?
A gun that marks the spot.
Okay.
Actually, I never looked it up, so I don't have a clue to that.
Okay. That was a question that arose to me. California defines a number of devices as firearms, but most people are really familiar with handguns, shotguns, and rifles. And then we also hear about other certain weapons being classified as assault weapons. How are these various firearms classified?
Let's take them one at a time.
Or defined, I should say.
Right. Let's take them one at a time.
What is a handgun?
Handgun is a pistol, a revolver, or other firearm capable of being concealed on a person. That's very important language. Capable. Not that it is, but it's capable of being concealed on a person. And it's got a barrel of less than 16 inches. Or any device with a barrel that's more than 16 inches that can be changed to a firearm with a barrel of less than 16 inches. There are certain firearms that are manufactured today that you can convert from pistol to rifle, shotgun. It's the same receiver. All you do is change the barrel, but it is still classified as a handgun. And one of the questions that comes up, I'm jumping off subject here, is that that particular weapon with a 410 shotgun shell, which will also shoot a 45, if it's less than 16 inches, it's illegal, the barrel, less than 16 inches, because it's classified as a sawed-off shotgun. But if the barrel is longer than 16 inches, then it is a shotgun, even though you can change the barrel out. That's why some of this can get a little confusing.
Well, that's kind of curious, but if you have one of these interchangeable barrels and you have the rifle barrel in it, is it considered a rifle or a pistol?
If the barrel is less than 16 inches and you've got a shotgun shell in it, it's a rifle. I mean, it's a pistol. Okay. Okay. But you can't put it. That came out wrong. If it's got the shotgun shell in it, it is a sawed-off shotgun. If you've got a 45 caliber round in it, which will fit, okay, then it is a pistol. Well, that's why you can't. There's a particular revolver that's out there that will take either 45 or 410, is not supposed to be imported into the state of California.
That's right, California has legal and illegal weapons, but we can talk about that later. But
yeah.
What is a shotgun you were talking about?
Shotgun is kind of interesting. They're unique in that we hear of various calibers and so forth. Shotgun is the only one that really is measured in inches. Okay. Well, I shouldn't say that. That's not entirely true. The 410 is measured in inches, and we hear 10 gauge, 12 gauge, 16 gauge, 20 gauge. And I was going to get into the description, but those have absolutely nothing to do with the diameter. But there was a special way of determining how much shot that they would hold, which came up with the different gauges. Again, I'm not going to get into it, but in California definition is, first of all, it's fired from the shoulder, which uses the energy of a fixed shell to fire a number of small spherical pellets called shot, or solid projectile called a slug. Now, somebody may get into an argument, well, these aren't small round shots, they're not spherical, they're square. I don't think that the law would particularly care. If it fits the definition of a shotgun, that's what it'll be classified as.
I'm kind of curious, is that designed to be fired from the shoulder?
And we're going to get into what we call certain guns that have certain characteristics that may be a shotgun that has no stock on it that you put on your shoulder, but has got two hand grips. May not be California legal. Now, we know it as a shotgun, but they classified it because of its characteristics. Could be as an assault weapon.
Interesting. What is a rifle, Steve? What's categorized as a rifle?
Again, we're talking about a weapon designed to be shot from the shoulder. Now here, you talked about rifling, or the helical groove or pattern of grooves inside of the barrel. Now this is what made black powder guns so unique, is that you could put shot or a slug into a smooth barrel. Also, you lost accuracy at the same time, but a rifle really does have rifling. Now, we know pistols do too, but the definition in California of rifle it does have rifling.
So that's kind of where the term rifle came from, was the rifling inside the rifle.
I would say so, yes, but my belief is that rifles have been called rifles long before, and why, I don't know.
Yeah, if it doesn't have rifling, is it a rifle?
If it has no rifling, then typically you would see it as a shotgun. But I don't know of anybody that would make for instance, a 30 caliber rifle with no rifling in it, because you've lost the ability or the control of or accuracy of the weapon. So somebody may do it out there. I don't know who they may be or what manufacturer they may be, but definitely in the state of California, the definition of rifle, it's got to have rifling in the barrel.
Interesting. Some types of firearms are automatically excluded in California. And cane gun, wallet gun, zip guns, automatic firearms, and machine guns. Don't buy them off the internet and have them shipped here.
And some of these things may be legal in other states. I don't think zip guns are, but cane guns I've seen, they were apparently a big thing in the 1800s. England, there were a number of manufacturers that made all kinds of different things into firearms. But those four things that you mentioned are specifically precluded or excluded. You can't own them in the state of California. Also, if you've got a short-barreled rifle of less than 16 inches, where somebody's cut the barrel off, it's illegal in California. Shotgun, we've all heard about sawed-off shotguns. If it's got a barrel less than 18 inches, it's automatically illegal in California. Assault weapons. Now, you can actually have an assault weapon with certain permit, but we're not going to get into that because most people don't have them, don't have assault weapons, and certainly don't have the permits, whether or not they've got the weapon. And firearms that of certain characteristics, which I've mentioned a couple times now, we'll talk about in a little bit. But again, this is where that antique thing falls in. The 1898 is the cutoff for antiques. Now they're excluded.
What are the firearms that are prohibited because they're classified as assault weapons?
This is relatively recent law. Now, machine guns have been governed by the federal government for a long time. Actually, they were not necessarily illegal. You had to get a special license. The only problem was they weren't issuing the license. So without the license, you couldn't have the gun. You couldn't get the license because they weren't issuing any. Therefore, it was illegal. But in California, anything that's designed after the AK, the Kalashnikov, the AR-15, are automatically illegal in California. Now, these are the original designs. There are some modern modifications that have made some of the AR style of guns legal, but generally anything that's AK or AR-15 are automatically deemed to be assault weapons in the state of California.
Are there other firearms that are deemed assault weapons because they have certain characteristics about the way they look or appear?
And we will talk about those, but the short answer is yes. Now, the Attorney General does have on their website an assault weapons assault weapons identification guide. But in looking at it, well, it looks good. It hasn't been updated since 2001. Nice photographs to look at. You may be able to identify a firearm that's been passed along through the family, and you better get a whole lawyer or licensed gun dealer to ask how do you get rid of it if you happen to have it. But it's an interesting guide to look at. And again, it's available, and we'll give a website in a little bit here.
What about handguns, Steve?
Well, handguns, as I described before, okay?
But the firearms, I mean, they could have certain characteristics that make them appear.
Exactly. This is where we're talking about the characteristics firearms, where they're otherwise legal in the state of California. These things usually apply to semi-automatic rifles that use center fire cartridge and have a detachable magazine and have any number of characteristics, such as a pistol grip. Now, defined in California as a pistol grip that protrudes below the action of the weapon.
What do you mean below the action? So
That is where most of the components are contained above the trigger.
Okay.
Okay?
Okay.
Anything above the trigger essentially is the action.
Okay.
All right? A thumb hole stock, a folding or telescopic stock, a grenade or flare launcher, that would seem to be, like, do you even need to ask? A flash suppressor. We see a lot of issues over muzzle brakes versus flash suppressors. It gets really technical, and if you're unsure what you have, go talk to a licensed gun dealer. They can tell you whether or not you need to get that thing off. Also, if the firearm has got a forward pistol grip. Now, if you're unsure what some of these things are, take a look at the military channel sometime and look at some of the firearms our soldiers are carrying. You'll see many of these characteristics, and that's why you can't own those guns in California.
I think you gave some really good advice there. If you have a question, go to a licensed firearm dealer. They're usually pretty knowledgeable
Correct.
about what can and can't. But there are certain handguns that aren't allowed too. Then they have characteristics that California doesn't want. Am I correct?
Exactly. Here again, we're talking about semi-automatic firearms. Here with a fixed magazine that holds more than 10 rounds. And that's why we've seen a lot of issues over the banning of certain magazines that held more than 10 rounds. And you can actually own them, but you can't sell them. There's a lot of laws. Again, talk to a licensed gun dealer and say, I've got this firearm and this is what it has for a magazine. Is it legal or illegal?
Isn't that applicable in rifles as well? The number that the magazine can hold?
If it extends below the action.
Interesting. Okay. How about shotguns?
Again, talking about semi-automatic. All right, that's got a detachable magazine or any shotgun with a revolving cylinder. And yes, there is a shotgun that is manufactured out there with a revolving cylinder. Again, a telescopic or a folding stock or a pistol grip, thumb hole stock, or a vertical hand grip. In other words, forward of the action where you can really hang on to that thing.
Well, it seems after discussing this and, and my personal experience also, there could be a lot of confusion about this. I mean, what firearms are prohibited? What about firearms that were legal when they're purchased, but they may be illegal now? I mean, where do I go and get the answers?
It is real tough. And if a person's got access to the internet, that's probably one of the better places to go. And first of all, the Attorney General's website at www.ag.ca.gov. We're going to show you these on the screen right now. And follow the links on that website to firearms. However, understand that their most current publication dealing with California firearms book, the handbook, was 2006. They've never updated it since that time, at least putting it on their website. But there are other non-governmental websites that also cover California firearms laws. Cal Guns, which you see listed on the screen, California Rifle and Pistol Association, crpa.org. And that's, by the way, one of the best firearms law summaries I've ever seen. Every year they send me a summary of California laws. It's an excellent handout. Also the National Rifle Association, NRA.org. Those are different places that you can go to research California gun laws if you've got just a general question. It's kind of interesting reading, believe it or not. And there are other websites that you may be able to go to that we're not going to show you on the screen today that cover firearms laws in other states. The problem of traveling from California into another state. Even if you may have a concealed weapons permit in California, it is not recognized in, as far as I know, any other state. And California doesn't recognize concealed weapons permits from other states either. So do your homework.
That gets very complicated about reciprocity between the states, and you have to really do your homework and also know which county you're in, too. There's been a lot of dispute. I won't get into it. But.
Right. There has been a lot of controversy, and so far there's not been a case that has gone up to the Supreme Court of the United States to decide whether or not there has to be reciprocity between the states on firearms laws. I'm just going to make a guess and say that every state can set their own laws, and there won't be any reciprocity required by federal ruling.
One of those states' rights issues we were talking about
Correct.
in an earlier show. One of the problems as attorneys, Steve, that we see on an almost daily basis is whether someone's prohibited from owning a firearm? And I'm sure people would want to know about that as a layperson as well.
The simple one is anybody who's convicted of a felony, it's a lifetime ban on owning a firearm. And there are certain misdemeanors that a person can be precluded from owning a firearm, possessing it or owning it, either one, especially if they've been convicted of assault or domestic violence. In the state of California, it's a 10-year ban for those misdemeanors. However, federally, there may be a lifetime ban.
Also, persons subject to a protective order or restraining order for the length of that order. What about the person that the order is to protect?
They're fine. It's the person that if I get a restraining order against you, I can own a firearm. You can't own or possess one. And those typically go on for a length of time up to 3 years. Now, I know that there's been some legislation trying to extend that to 5 years, but certainly during that time, you can't own or possess a firearm, or you could be subject to a felony.
Interesting.
Now, of course, also mental patients or people who are deemed to be a threat to themselves or others cannot own firearms. And understand that even though somebody has had their record expunged, in other words, they've gone to an attorney or gone to court, asked to be something expunged from their record, a prior felony or a prior misdemeanor, that doesn't necessarily mean that they can own or possess a firearm. This is where you really need to talk to an attorney because it gets complex. If people think, well, I've had my record expunged, I'm okay. In California, your record is really not expunged as such. They just add one more entry in your record saying that you were arrested, convicted, record expunged, but it all shows up on your record. Also, in addition to state laws, there are certain class of misdemeanors convictions under federal law that may preclude for ownership of a firearm. And in some instances,
well, in some instances, even if you're arrested and not convicted, you could be precluded from owning a firearm.
absolutely, there is an appeal process that the arrestee can go through saying, I was never convicted of an assault, but only disturbing the peace, but they actually have to apply to be able to own or possess a firearm. Now, when a person is precluded from owning or possessing a firearm, one has got to be real careful here, because ownership means very clearly they cannot own a firearm. But we also get into the issue of possession, whether actual or constructive. Now, I've got actual possession of this this coffee cup, but Bob's coffee cup over here is within reach. Arguably, I have constructive control over that firearm, or coffee cup in this case. So there's situations where a person could be arrested if they're precluded from owning a firearm if they had the ability to exercise some type of control over that firearm. It gets real tricky.
That could be a situation, could it not, where even a husband and wife living in the same house or in the same people in the same vehicle, and isn't it true even if your spouse is not precluded?
Right.
Then a knowledge issue, but I'll let you talk about that.
In the instance that you gave, the wife was convicted of a felony, I don't care how many years ago, the husband cannot have any firearms in that home. Now, one can say, well, what if they're locked in a gun safe? She doesn't have the combination. That's what you'll be telling the judge after she's been arrested as the defense. It doesn't stop the arrest. She can still be arrested because she's precluded from any actual or constructive possession of the firearm. But again, it's a defense and doesn't stop the arrest.
Another question I always hear about, and that is, what about home protection? What are our rights with firearms regarding home protection? I know that's a broad question.
It is. It's a very broad question, and we have to understand that there's some general rules. We'll just talk about the general rules because every situation that may be presented is different. Generally, the law says that you can defend your home against anyone who attempts to enter in a violent manner, intending violence to any person in your home. You can see by that definition that they attempted to restrict it down to some violent act. Now, that poses a question. What if somebody's trying to break a window? Do we know what they're going to do? Short answer is no, we don't. And that's where the best understanding you can get of the law is to take a good hard look at it before you take any actions, because the amount of force that you can use in resisting any entry is limited to that which appears necessary to a reasonable person of the same in the same or similar circumstance. Now that's something that we see under the law all the time. Similar person or reasonable person in similar circumstances is a standard set by law.
So the steps you can take for your own protection, they vary quite a bit.
Exactly. Depends on the situation. But also, in your own home, you're not required to retreat, even if it's safe for you to do so. Someone's trying to break down the front door, you can escape from the back door. You're not required to do that. You may protect your home. And force can be resisted by force in increasing proportions. If they're, I'll use the scale from 1 to 10. If they're at level 1, you can go to level 2. If they're at level 5, you better be at level 6. And of course, as it increases, fine. But if they're at level 1, the bad person, you don't jump to level 10. So also, remember that what I said, these are defenses. And there are 12 people going to judge whether or not they believe you acted as a reasonable person.
These aren't easy questions. There's no easy answers to this.
Right. Let's talk about self-defense. First of all, you have a right to defend yourself. And the general rule is much like protecting your home, or in other words, in proportion to the attacker's persistence and violence, level 1 through level 10. You're always a step ahead. That's the same thing when I was in law enforcement that we used. If we're trying to arrest somebody and they're resisting at level 1, you go to level 2 and right on up the scale. But generally a person, and also a person who begins the assault has no right to claim that they're defending themselves unless they say, stop, I'm through, it's over. Anything that the original victim does after that point, they now become the aggressor.
So there's no short answer.
No.
It's going to, based on what a jury's going to come back. What about the defense of someone's property?
Again, you have a right to request that a person leave. You have, if they refuse to leave, you have a right to use force to get them to leave. Obviously, the first thing we say is just call 911. That's what law enforcement's for. Let them do it. In many situations, self-help is not the best way to go. Okay. What I'd like to do, Bob, at this point is just tell people that because this area about firearms is can kind of be complex, do your homework, look at various websites, talk to an attorney, talk to law enforcement, but do your best to learn ahead of time before a situation arises so you know your rights. Thank you very much for joining us today on The Law and You. And we're going to show the websites again that we showed earlier.